Oh yay, oh yay, oh yay. This Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Welcome to the October docket of the Court of Criminal Appeals, the Eastern Division. On the panel today is Judge Camille McMullen from Memphis, Judge Jill Barty Ayers from Clarksville. I am Kelly Thomas from Maryville. Before we begin, I first want to thank Nick Morgan and Jim Hibner for actually making this possible. They coordinate everything, get everyone where they're supposed to be, and make sure all the technical things are working correctly. So thank you very much for making this something that we can actually do and make it happen. As usual, each side will have 20 minutes for your arguments. If the appellant wishes to reserve some time for rebuttal, let me know when you begin your argument and we will do that. I will give each of you a little heads up when you start getting close to the end of your argument. So I don't think there are any preliminary matters. So if you would, please call the case, Mr. Clark.
State of Tennessee versus Stephen Jacob McKinney.
All right, sir. Mr. Covert.
May it please the court, Clancy Covert for Stephen Jacob McKinney of the Chattanooga Bar. I would like to reserve 5 minutes rebuttal, Your Honor, if at all possible.
Certainly may.
May I begin, Your Honor?
You may.
Thank you, Your Honor. Your Honor, Your Honors, in May of 2019, Stephen Jacob McKinney and his best friend went out for a night of drinking, which resulted tragically in the death of Mr. Brent Johnson. My client, Mr. Stephen Jacob McKinney, was driving the vehicle, and his blood alcohol level at that time was over 3 times the legal limit. As a result, he was charged with a number of things, including vehicular homicide by intoxication. The district attorney at the time, a gentleman by the name of Chris Post, and I worked diligently and vigorously on this case. We ultimately resolved the case for a plea of vehicular homicide by intoxication. However, we agreed at that time as part of the plea agreement that it would result in an 8-year sentence with the method and manner of service to be discussed and argued before Judge Tom Greenholtz here in Chattanooga at the sentencing hearing. A pre-sentence investigation was done back in early December of last year. We had the sentencing hearing. There were several witnesses that testified. It was a very difficult and emotional hearing. The parties acknowledged the relationship between the deceased and my client. And as the court is probably well aware from its practice, and the judges are well aware, a lot of emotions took place. The ultimate result was that Judge Greenholtz decided that the 8-year sentence was to be served in the Tennessee Department of Corrections, but the central issue in the argument focused on the interplay between 2 statutes. Those statutes are TCA 3913-213, the vehicular homicide statute, and then the probation eligibility statute, which is 4035-303. With that in mind, Your Honors, the statutes that we are talking about first and foremost is the vehicular homicide statute. 3913-213 is the vehicular homicide statute. And what we're dealing with, and I hope that the judges can see on the screen the statute that I've put up there, we're dealing with subdivision B2B. Vehicular homicide under subdivision A2 is a class B felony. Any sentence imposed for a violation of subdivision A2 shall include a mandatory minimum sentence of 48 hours consecutive of incarceration. The person shall not be eligible for release from confinement on probation until the person has served the entire 48 minimum mandatory sentence. That's the first statute. The second statute that we are dealing with, and where the rub comes, so to speak, is 4035-303, which clearly says, and the appellant does not dispute, that a defendant shall be eligible for probation under this chapter if the sentence actually imposed is less than 10 years. However, no defendant shall be eligible for probation under this chapter if convicted of a violation, and I've highlighted there 3913-213A2. There's no dispute before the court. I'm not trying to perpetrate any frauds on the court. There's no dispute that that applies in this case. The issue that we're dealing with between the court, or between these two statutes, is this. The long and the short of it is, the appellant's position is the vehicular homicide statute clearly calls for some mandatory minimum, for a lack of a better term, jail sentence, which is 48 hours. Now, we submit that because of the language of the statute, it clearly says that it's a minimum. It's not a maximum, it's a minimum. So if there is a minimum jail sentence that's imposed by statute, then any release after that sentence is not to probation, it would be to parole. Okay. And even though the statute says that they can't be released from confinement on probation, we submit it would be, since it is because of a mandatory sentence, that it has to be to parole, and it's not to probation. Now, the argument, we made the similar argument to Judge Greenholz at the trial court level. To our knowledge, there's no case deciding the interplay between these two statutes. That's why there's very little case law, and your honors have the difficult determination of dealing with that. I understand what constitutional construction deals with. I submit that the state is right on the case laws that they have cited in that. The statute 4035-303 was changed after 3913-213. So statutory construction clearly says that the newer statute would control. However, I think that a close reading, and I think that these statutes do not conflict with one another because of the mandatory sentence. If there was no mandatory sentence, there would be a clear, the statutes would clearly be at odds. However, since there is a mandatory sentence, 4035-303 is satisfied by the service of at least 48 hours. Am I saying that my client deserves 48 hours in jail and then walks free? Absolutely not. I would not impose that upon the court. But I think under the vehicular homicide statute, the trial court has the discretion, if one is convicted, to impose a sentence of at least 48 hours, if not more. Now, so with that in mind, the court could free to impose a year, 2 years, whatever the court wanted to impose on that. So we respectfully submit on behalf of Mr. McKinney that the interplay of the statutes works if the trial court has a sentencing hearing and imposes at least 48 hours. If that imposition of 48 hours is imposed, or let's say it's 90 days or 120 days or 1 year, or 2 year, whatever it may be, when that sentence goes down and he's released, albeit even for 48 hours, that is a term of incarceration. So therefore it satisfies 4035-303, because there has been incarceration. And I think if you look at the legislative history behind that statute, we're all aware of years gone by before this statute came into effect where somebody's been convicted of vehicular homicide and received straight probation. I understand, and my client understands the need for the statute to read the way it reads. But if you look at 3913-213, it clearly gives the trial court the ability of a minimum of 48 hours in jail and then a release after that. We submit that release is not necessarily to probation, but because incarceration has happened, it would be to parole. Probation means you're released into the community in lieu of incarceration. Okay. Parole, on the other hand, is release after incarceration. So if there's incarceration involved, we submit that it would be, whether it's 48 hours, 90 days, 120 days, whatever the trial judge has the discretion to impose, but more than 48 hours, we submit that would be to parole.
Let's say the judge decided that a defendant should serve a year.
Yes, sir.
How do you say that the judgment should read?
The judgment should read.
An 8-year sentence, serve a minimum mandatory of a year. How would that judgment read?
Well, I think that the court could put down the judgment of, in this case, we agreed to an 8-year sentence.
Okay.
And the judgment would go down that it would be basically split confinement, where he would be in jail to serve day for day 1 year and then released subject to the parole order or the judgment of the court. I mean, if he's released on parole, he gets out after that. If the court wants him to do 90 days of rehab or 30 days of community service or whatever the case may be, those are conditions that the court could put upon him or any defendant like they do in other judgments. So I think that the judgment of 8 years, so he would serve a year, he would have 7 years on parole, so to speak, to continue reporting to the state of Tennessee after that. And then whatever conditions the judge imposed upon him, community service, working with victim impact groups, whatever the case may be, could also be added in there.
Do you know of any other, accepting what you're saying for the sake of argument,
Yes, sir.
do you know of any other statutes that authorize the trial judge to set the parole date?
No, Your Honor, I'm unaware of that. But I think that the reading of this statute clearly says, since it says shall include a minimum sentence of 48 hours of incarceration, since it says minimum, if it just said shall include a mandatory sentence of 48 hours, then the court would not have discretion. So I think the statute gives the discretion to the judge to impose at least 48 hours, if not more, plus additional conditions, if the court so chose. That's all I have, Your Honor, at this time.
Okay.
Your
Did
Honor.
you tell me you wanted 3 minutes or 5 minutes for rebuttal?
5 minutes, Your Honor.
Okay, that's what I wrote down, but I didn't trust myself. Okay.
Yes, sir.
General Ward.
Good morning, Your Honors, and may it please the court. My name is Garrett Ward, and I'm here today on behalf of the state in the matter of State versus Stephen McKinney. Your Honors, this case, I agree with opposing counsel, really concerns the interplay between two statutes, the statute governing probation eligibility and the statute governing vehicular homicide. In 2015, the vehicular homicide statute, that's TCA 3913-213, was amended to add that probation was not possible for people convicted of vehicular homicide by intoxication until they had served 48 hours. Because at that time, it was possible for somebody who was convicted of vehicular homicide to receive an entirely probated sentence while there was mandatory service provided for in the DUI statute. And the General Assembly sought to sort of rectify that imbalance between those two statutes. 2 years later, in 2017, the General Assembly amended the statute that overall governs probation eligibility. And in no uncertain terms, in 2017, the General Assembly amended TCA 4035-303, amended that statute to specifically provide that persons convicted for vehicular homicide by intoxication were not eligible for probation, period. The clear intent, if this court, I would submit to this court that the plain language of the amendment to the probation eligibility statute in 2017, that the plain language of that amendment is that there is no release eligibility possible for a person convicted of vehicular homicide by intoxication. I think the words speak for themselves. However, if this court would were to choose to examine some of the legislative history behind the 2017 amendment, I would submit that it supports the state's position that what the General Assembly was attempting to do in that 2017 amendment was to essentially remove release eligibility for persons convicted of vehicular homicide by intoxication. Your Honors, I don't think that the reading of these two statutes suggested by the state causes any sort of conflict. I direct this court back to the vehicular homicide statute. That statute's very clear that any contemplation of probation that occurs within that statute is solely and only pursuant to 4035-303. So what we have here is the vehicular homicide statute saying that, whatever 4035-303 says, pursuant to that, here's what we feel about possible probation. And what 4035-303 says is there is no possible probation for a person convicted of vehicular homicide by intoxication. The defendant here was convicted of vehicular homicide by intoxication. So I would submit to the court that the plain language of both of these two statutes leads to one conclusion, that the defendant here was not eligible for probation, that he must serve his sentence in confinement. Briefly dealing with a defendant's suggestion that perhaps the trial court would be setting a sort of a parole date rather than ordering probation. It seems, Your Honors, is what the defendant is asking for is essentially a split confinement sentence, and that to avoid the plain language and intent of the General Assembly's amendment, he just asked this court to consider it parole rather than probation. And Your Honors, the state is not aware of any other statute or piece of Tennessee law that works in this manner, where parole is all of a sudden the province of the trial court rather than the typical parole entity, the parole board. Your Honors, the defendant's reading of the statute essentially renders the 2017 amendment to the probation eligibility statute meaningless. The clear language of that statute, the legislative history supports this. The clear purpose of that statute is to remove release eligibility, the possibility of release eligibility for persons convicted of vehicular homicide by intoxication.
Are you saying that when you say remove release eligibility, are you meaning within, any kind of probation whatsoever, whether complete, following split confinement, periodic confinement, whatever? Or are you saying that it removes parole eligibility as well?
It would not, pardon me, Your Honor, if I overspoke, it would not remove parole eligibility. It does entirely remove, however, probation eligibility. The statute
of any form, not just total probation, but any kind of probation.
I believe that's the plain language of the statute, Your Honor.
Okay.
It's a person convicted of vehicular homicide by intoxication is not eligible for probation.
Okay.
And given that a person convicted of vehicular homicide pursuant to the statute is not eligible for probation, I would submit to this court that the trial court was correct in rendering its sentencing decision. And unless this court has any further questions, the state would ask that the judgment of the trial court be affirmed.
Thank you. Mr. Covert, your rebuttal?
Yes, Your Honor, I appreciate that. And I appreciate the state's argument. They've been great to deal with throughout this process, Your Honor, and I commend Mr. Ward in his argument. Your Honor asked me a question a moment ago, and I've had a little bit more time to think about it. A lot of times you will see cases that are resolved by agreement. I did one just the other day where the parties agree the client's going to serve 5 years, day for day. Okay. And if it's day for day, he or she goes and serves that day for day. And I would suspect that Your Honors have seen agreements such as that and have likely approved that at the trial court level when you were judges. So for the trial court to say someone is going to serve a day-for-day sentence, whether it's 48 hours, 90 days, 180 days, 365 days, whatever the case may be, I don't think that invades the province of the Tennessee Department of Corrections. It happens every day by agreement that are approved by the trial court level. So for the court in this situation to render a judgment of 1 year, 2 year, a year and a half, 18 months, 90 days, whatever the case may be, day for day, that imposition, whether it's served in the Hamilton County Jail, the Bledsoe County Jail, wherever, as your honors are aware, there are Tennessee Department of Correction inmates all over the state in county jails. Wherever that's served, it is still a Tennessee Department of Correction sentence. So if the judge is given the authority, and we submit that they are under the statute, for it to impose at least a mandatory minimum sentence of 48 hours, and it could be a lot greater than that, your honors. If they are allowed to do that, then they can set the terms, and by setting those terms, and by virtue of the statute, there is a mandatory jail sentence. And since there is a mandatory jail sentence, 4035-303 has been satisfied because it is not a 100% probation case. That is our position, your honor.
Very well, thank you. Appreciate your arguments, gentlemen.
Thank you. Thank you, your honor.
Conclude this case, and Mr. Clerk, if you would recess us, I guess.
This honorable court is now in recess until 10:30 a.m.
Thank you.